What is the history of privacy rights, from ancient ideas to digital law? Imagine living in a world where your personal space and thoughts are constantly under watch. Privacy rights have come a long way from those early days. Let's explore how they evolved over centuries to protect us today. Long ago, privacy was mainly about physical spaces and personal letters. Back in the 14th century, courts started addressing issues like eavesdropping and opening private correspondence. Early Americans worried about sharing family details during the first U.S. Census in 1790, fearing neighbors might see too much. These concerns focused on physical intrusion and unwanted observation. The U.S. Constitution, ratified in 1789, doesn't mention privacy directly, but courts have interpreted some amendments as protecting personal privacy. The First Amendment guarantees freedom of belief. The Third Amendment prevents soldiers from quartering in homes without permission. The Fourth Amendment guards against unreasonable searches and seizures. The Fifth Amendment protects against self-incrimination. The 14th Amendment's Due Process Clause has also been seen as a way to protect privacy rights. A big turning point was in 1890 when Samuel Warren and Louis Brandeis published an article called The Right to Privacy. They argued that privacy should be a legal right, especially with new inventions like instant photography and sensational journalism invading personal lives. They introduced the phrase, the right to be let alone, which became a foundation for future privacy laws. In the early 20th century, privacy laws started to develop, often at the state level. California, for example, made laws protecting a person's name and likeness from commercial use. The Federal Trade Commission, created in 1914, later took on the role of stopping unfair practices related to privacy online. During the 1960s and 1970s, privacy rights expanded even more. The American Law Institute recognized privacy as a legal tort, meaning you could sue if someone invaded your privacy. The U.S. Supreme Court also made important rulings to protect personal privacy from government intrusion. A key law was the Privacy Act of 1974. It set rules for how federal agencies could collect, use, and share personal data. This law was a response to growing worries about government surveillance and data mishandling. Over time, more laws appeared to regulate privacy in different areas. When digital technology took off, new privacy challenges appeared. Data collection, online tracking, and digital surveillance became major concerns. Laws and rules have kept evolving to protect digital privacy. Agencies like the Federal Trade Commission now work to prevent deceptive and unfair online practices. Understanding this history helps you see how privacy rights have grown from protecting physical spaces and letters to safeguarding your personal information online. Today, you have legal protections against unauthorized data collection, surveillance, and misuse. But staying aware of your rights is key. Knowing your rights means recognizing that the Constitution and laws protect you from unreasonable searches and data collection. You have rights about how your personal data is gathered and shared by both government and private companies. Laws like the Privacy Act of 1970 and agencies like the Federal Trade Commission help enforce these protections. To protect your digital privacy, you should manage app permissions, use secure messaging tools, and know how to access or correct your data. The history of privacy rights shows a continuous effort to balance personal freedoms with societal needs. Being aware of this history helps you better defend your privacy in today's digital world.